Today on the podcast, talking about some of the crazier contract stuff that I've seen in my day.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome to the podcast. My name is Rob. I'll be your host. And I'm extremely excited today because this will be, if I'm not mistaken, the first episode where it's not completely dedicated to the bummer of the coronavirus. Uh, I feel like that's dedicated, or all of my time has been dedicated to that for the past several weeks and months. So it's good to get into material that's useful for you guys that doesn't necessarily have to do with the coronavirus. I think I've said everything I could possibly say about the coronavirus up until now. So you get a temporary reprieve from me and COVID-19. I will not mention it again the rest of the episode. It's kind of like, what was that, Harry Potter? Who's the bad guy in Harry Potter, Bagels? Who's the bad guy in Harry Potter? Voldemort. The person who you won't mention their name. Is that not how it goes? I think it goes something like that. Yeah. So a couple of housekeeping matters before I get into the material. The first thing is, if you like what you're hearing, please subscribe, either on YouTube or wherever you get your podcasts from. And I have another ask, and that is to give me some love on Instagram. I'm trying to understand and learn Instagram. I'm kind of like your middle-aged dad navigating these waters. So I'm making lots of mistakes and doing that, but it would be great if you could follow me. I'll be forever grateful if you can do that. And then if you have any suggestions for what topics and what content you want covered on the podcast, shoot me an email. That would be fantastic, or comments on the YouTube channel, wherever I'm at, reach out. If you see me at Taco Bell, actually you won't see me at Taco Bell for a while for reasons I won't mention because I've already said I wouldn't mention it. But in the future, if you see me at Taco Bell, say, hey, Rob, talk about this. No problem. I desire any feedback you got, good, bad, the ugly. In fact, this episode is the result of listener feedback. We got a comment on our YouTube channel a few weeks ago from a really nice guy named Madison Raiz up in New York. He does New York PhotoBus, and his suggestion was, Rob, talk about some of the more crazy stuff you've seen in contracts, some of the worst things you've seen in contracts, and some of the good things you've seen in contracts. And so that's kind of how I got the idea of this podcast. So I'm just going to go through a few of the more zany things that I've seen in contracts and talk about perhaps why, from a legal standpoint, you don't want to have these things. And I guess at the outset, I want to say, like, there are plenty of crazy things that I've seen, but a lot of them go without saying. So what I'm covering today is kind of, you might see these, and I want to tell you about why they're bad, XYZ, but they still fall, in my opinion, into the zany, wild wackiness of contract law. So without further ado, let's get into this. And again, thank you, Madison, for the suggestion. So shout out to him. Again, like and subscribe, watch it on the YouTubes. Okay. So if you hear that snort, which I think you do, because I'm not a very good I'm not a good audiologist with the equipment, but that is in fact my wife working in the background. We are sharing the same office as we both work from home for reasons that I will not mention. So at any rate, okay, here we go. First thing that's kind of zany is in a contract that I saw maybe a couple years ago. It essentially was like this: wedding professional and client can terminate contract at any time for any reason, and then something along the lines of without penalty. So you could theoretically, you could sign this contract a year in advance, do all this work, and then the day before, the client could say, you know what, you're fired, out of here, with pretty much no ramifications at all, and vice versa, for any reason at all. It was crazy. And why is that crazy? Because I would argue that under the laws of many states, that you don't have a contract. A contract is a promise in exchange for another promise. I promise to give you $500. You promise to show up and DJ my wedding. That can be a legally enforceable contract because I'm promising to do something that I otherwise wouldn't have to do, which is give you $500. And you're promising to do something that you wouldn't otherwise have to do, which is to DJ my wedding. Okay. So what happens is when you have a promise that you are saying, I don't have to fulfill if I don't want to. In the law, sometimes we call that an illusory promise, meaning I promise to do what I say I'm going to do unless I feel like I don't want to do it anymore. Then really you don't have a promise. And if you don't have that promise, you don't have a contract. So you've got two people saying, I swear to you, I swear on my mother's grave, I will show up at that wedding and do what I'm supposed to do unless I don't feel like it. Not if there's a tornado, not if I'm dead, not if the other person has done something to make it kind of like quote unquote for cause, although I'm not using that word. So for example, if they didn't pay me, if, they kicked my puppy, if, they defame me on the internet, no reason like that. It could be, the contract was written in such a way that it was for any reason. And so both parties are saying, I got your back unless I don't feel like it. And when you have that, you have sometimes what the law calls an illusory promise, and you don't have a contract. A contract requires an exchange of promises, among other things. I mean, this is not, don't go to the bank on this, but there are other issues, but essentially it's two promises and that locks you in. The first promise of giving $500 locks the other person in when they say, yeah, I'll take that $500 and I'll DJ that wedding. And so once you are in the position where I don't have to give you $500 if I don't want to, then you have nothing. And outside of the wedding industry realm, I litigated a case in which that was absolutely what happened. You had, it was agreement between a partnership, like a venture capital, whatever, investing in some type of software. And it was essentially like, after a couple of years, if we don't like what we're doing, we're out of here, blah, blah, blah. And we made the argument that there was no contract at all. And, of course we settled. Maybe it would have made it somewhere. I don't know, but we had a strong argument under the law of the state that we were in, that because of the fact that we had a promise, except if we didn't feel like the promise, we had absolutely no contract at all. So that was one of the more crazier things. And I don't know what's going through the person's head when they, write these things or steal them from the internet. But, it's one of those times where I'm like, hey, this is when you follow this clause to its logical conclusion, this is what can happen to you. And it's like, you know what? I never thought about that. Let's change that up. So sometimes, not to pick on the person that had this, but that's really what you're looking at. Sometimes you have these contracts and you don't know what they're saying. And sometimes it can lead you down a road you don't want to go. So I'm not saying that there are not contract clauses that you can have in your contract that allow you to terminate the contract for XYZ reason. However, typically, if the XYZ reason is just because you feel like it or because you want to, then in most states, you probably do not have a contract. So how that boils down in real life is that you'll have a contract that says something along the lines of payment. If you don't pay me, I can terminate. If you, kick my puppy, I can terminate you. These, a litany or list of reasons that give rise to the discharge of your duties under that contract. That's typically how that would work, but not, again, to kick a puppy. Again, not in the instance where you just don't feel like doing it anymore. It's an illusory promise and typically will not be viewed as a contract at all. So that's, in a nutshell, one of the more crazy things I've seen in the past. I think the next thing, and I've used this as an example in when I talk about non-refundable deposits in seminars and webinars and things like that. But um, the one of the crazier things, and this was interesting because this is, I mean, like my clients will run the spectrum of somebody just starting off with no clients and charging, essentially rock bottom, like student rates, like the type of when you go to the haircut place and it's students, and so you can get a haircut for like $4. That type of client. I have those clients. All the way to, nationally renowned people that it's expensive to hire them. And this particular client falls to the more expensive side of that. And essentially it boiled down to they took two payments, essentially. The first payment due obviously at signing, the second payment due a certain amount of time before the event. And it could have been 30 or 45, 60 days. In this instance, doesn't matter. But the first payment was, regardless of how large the contract was, whether it was a $25,000 contract, $10,000, 50,000, didn't matter. The first payment was always a nominal amount, like a small amount. I can't remember what it was, but it was something like $500. So following that to its logical conclusion, you could have a $25,000 contract in which the client put down only $500 and would receive services up until the 60, the 45, or the 30 days before the event, and they would plop down the rest. So the reason why that's zany is because, and I've talked about this in other seminars, and we can talk about this on other podcast episodes. I don't want to spend a lot of time on that, but you are exposed in terms of losing money if that wedding is canceled based on what the client does. So if the client gets cold feet or whatever, you've done a lot of work. Theoretically, you've done a lot of work. If it's a $25,000 contract, you've done a lot of work up until 60 days before the wedding. And then if they cancel the wedding, then you're having to go after and chase the money that would be yours. Theoretically, whatever your expectation damages are from the $25,000. So I'm like, client, what are you thinking? Like, you're exposed, your ass is in the wind. If this event cancels at some point between the day that you sign this contract and get $500 and 60 or 45 or 30 days before you get the rest of the money, you've done a lot of the work. And in some instances, you've probably done almost all of the work except for the coordination day of. How much is that worth? You're chasing the money. You'll never get money when you chase the money, essentially. So I always thought that was super crazy because that first payment was so misrepresentative of the work done and the risk of cancellation based on the contract value. Now, it's a different I'm not saying don't take $500. I'm saying that a lot of times it's best practices not to take $500 if the contract value is $25,000. If the contract is $1,000, that's a different story. You're not as exposed. You're not at risk of losing everything by not getting that second payment. So having some type of payment system in which your butt's in the wind, it's bad news, Brown. And it's that was one of the more crazy things that I've seen in a while, just by the experience and the contract value that these people had and how that worked. I thought that was kind of crazy. All right. What's next? What is next? The next thing that I remember now is I've had potential clients, and I've had only, I think, one actual client that has this, but it is what I would call a no review clause, meaning that when the professional signs up the client at that time is agreeing not to review the performance of the wedding professional. In other words, at the outset of the contract, the client, whether the performance is good or bad, whether the DJ showed up or didn't show up, whether the photographer, took pictures of their own junk or not, the client will not go to Google, Yelp, the not, whatever the case may be, and review, good or bad, the wedding professional. No review clause. So why is that crazy? Why is that not kosher these days? And the reason is because I know of at least a couple states, first of all, that have outlawed it. In other words, you cannot do it at all. You are prohibited by statute from having a contract that prevents the client from reviewing you. So from the outset, you might be prohibited from the get-go. But mostly, I mean, if you're of the mindset that you have to prevent bad reviews by making it a contractual obligation, then you might want to reconsider what you do. You might need a business coach. Because whenever I see that, I run away. I run away fast because that's telling me, I mean, if you can't stand behind your word, like what's going on here? Now, I understand that people will troll, people will try to exploit you in order to get refunds or whatever it is. Trust me, I've seen it. I understand what that is, but that doesn't mean that you should do it. So I've always recommended that first of all, never have them in your contract. Never have those in your contract. That's what my recommend. I mean, I'm not giving you legal advice. Depending on what state you're in, you may or may not be able to have it as a um, as a legal concern. You might be able to have it or not. I'm saying you might not, just depending on where you're at. But from a customer relation standpoint, it's terrible. From a customer relation standpoint, you're telling the client, I'm bulletproof, baby. Like, you don't worry about it. I can do whatever I want, and you can't say anything about it. No way. But I get it. One bad review can really hurt you. And typically it happens once things go south. So while I'm saying that I don't recommend it at the beginning, that doesn't mean that you can't bargain for silence somewhere down the road. Now, and again, I'll have another podcast dedicated to this because I don't want to step on Madison's toes. I want to talk about the different contract things that don't make no sense. But sometimes if there's an issue that comes up, let's just say that the client is mad about something. Like, I'm mad that, I don't know, you said you're going to give me coordination services. You're going to have enough assistance to, have somebody constantly around the bride and somebody around the groom, and then another one that's coordinating with the vendors at all times. You said that you're going to have at least 3 persons. You only had 2. And let's say that's true. What you could do, if you're the professional that failed in that particular portion of the contract, meaning that you didn't have enough people, you could say something along the lines of, okay, I'll give you X amount of dollars in exchange. And you promise not to sue me. And then you can say you promise not to give me a poor review. Essentially what you're doing is depending on what state you're in, but it's essentially you're renegotiating the contract that you already have. You're amending the contract that you already have, or in some jurisdictions, it's accord and satisfaction. I don't want to get into that, but it's essentially a new contract. It's not the original one. It's a new one. You're saying, okay, to the extent that I might have messed up or not, I'm giving you money in exchange for don't give me a bad review, or I'm giving you money in exchange for you don't sue me. That's perfectly acceptable. And that happens all the time. not just in the wedding industry, but in every industry. I mean, there are very few companies that have, been in litigation that haven't settled and made the terms of the settlement confidential. That's 1,000 times a day action going on there. So there's no reason why you can't do that. You just can't do it in some states at the beginning from a statutory standpoint, a legal standpoint, but from a business standpoint, terrible. So that's wacky stuff. I usually tell my clients, I strike that out. I'm like, man, you got to get rid of that. The other thing, another thing that I haven't seen this very much, maybe once or twice, where, and if this is, you're talking about planners and you're talking about coordinators, you're talking about people that have to essentially contract on behalf of the client. So the planner is the planner's job is to go and get, it's kind of like a turnkey thing. The planner's got to go and get the band. Planner's got to go and seal in the venue. The issues that I'm seeing that are kind of crazy is when you have a planner that has a contract in such a way, rewarded in such a way, is that they leave their butt in the wind with who is responsible if the client cancels the event. And here's the wedding planner who has signed all these contracts on behalf of the client. See what I'm saying? You got the planner signing the contract with the venue, with the band, with the DJ, and not the clients themselves. And so in some instances, that's going to leave the planner potentially liable depending on the contract. And if the contract is not specific to, I'm acting on your behalf, XYZ, or you need to sign blah blah blah, if that stuff's not handled, then that definitely leaves a planner exposed. So I've seen that in the past, and luckily, when I was involved, the client wasn't of the mind of, I didn't agree to that contract or that amount, or I didn't agree to be obligated to XYZ if the wedding was canceled. They were on board with it. It was okay in that particular instance. But if they hadn't been okay, I was scratching my head based on the way that this contract was worded. I would the planner have ultimately been successful? Possibly, because sometimes, depending on where you're at, the law is going to assume that the planner is acting on behalf of the client, but maybe not if it's not addressed in the contract. So I always thought that was a crazy, wacky, wild. I mean, not wacky wild in the general sense of life, but wacky wild in the general sense of what I do, which is fairly boring. So I thought that was kind of interesting. It was going to leave this planner potentially on the hook for the client canceling the wedding because the planner is the one that signed all these contracts. So that was kind of wild, which kind of makes me segue into the next thing. And this is not something that's particular to the wedding industry. This is a lot of the business clients that I've had sometimes deal with this issue. But do you ever wonder why some of the contracts that you sign, it'll have the little signature line and you sign your little signature to it. And then it'll have like it says by, and then a title. Okay. And then maybe representing, and you put in the by, you put, the name, and the title, you put CEO or owner or member or whatever. And then in the company, you put the company. The reason why most of the time that's going down is because from a legal standpoint, there is a huge difference between Jane Doe individually as a person walking down the street, hanging out, and Jane Doe as the president of, I don't know, Sassy Event Planners, Jane Doe, CEO of, Twin Oaks Floral Company. There's a difference in the law between when a person is acting in their individual capacity and in the capacity as a representative of a company. Companies are legal fictions. I mean, I can't walk down the street and punch a company in the face. Like they're not humans in the flesh. They're humans in course the Supreme Court, But companies can only act through people. People act on behalf of companies. So some of the stranger things that I've seen is when contracts specify that it's Jane Doe contracting with the client. Jane Doe's home address, Jane Doe individually, or writing to that extent, and not Jane Doe as the member owner or the president or the whatever of XYZ company. That leaves Jane Doe liable if there's a problem, or potentially liable. So, and a lot of times judges don't give a crap about things outside of the contract. And definitely that will depend on what state you're in. Sometimes judges, it's really, I'm only caring about what's on this paper. And if what's on this paper is Jane Doe individually is the planner and not this company, then that's what y'all decided. Who am I to say? I can't read your minds. I'm only going off this paper. And you don't want that as the professional. Unless that's what unless you're a sole proprietor, and we won't get into that. But if you have a company and the company is the one that is doing the work, then the contract should reflect that it's the company doing the work. It just so happens that you're the one that's signing the contract on behalf of the company. So that's always been kind of wacky wild to me when the contracts they're written in such a way that it appears that there is no company, that it's a person, when in fact that's not the case. If it is the case, that's perfectly okay. If you're a sole proprietor, hopefully you'll have general liability insurance. That would be fantastic. If you're a sole proprietor, in other words, if you're, Jane Doe doing business as whatever, fine. But if there's, if you've got a company, if you got a business, especially if it's not your business, especially if it's not your business. In other words, somebody else owns it. Definitely want to make sure that that's how the contract is written. We are already over 25 minutes. I cannot believe it. I could literally talk about this stuff literally all day. Literally. Anyway, once again, folks, thank you so much to Madison Raiz, New York PhotoBus. He suggested this topic. Hopefully you found a little bit of this informational, perhaps entertaining. I doubt it. Doubt it to the entertaining part. The education part, hopefully. If you have any suggestions for content, please let me know in the comments on the YouTube, or you can email me, rob@weddingindustrylaw.com. Hit me up on Instagram. I think that I'm at Wedding Lawyer. I don't even know if that's what you're supposed to say on Instagram, if it's at something. I think that might be Twitter. That is how ridiculously behind the time I am with Instagram. I think I'm Wedding Lawyer. I think I am. Who knows? Find me on there. Check me out there. Madison's suggestion was to do the worst things, or some of the crazier things that I've seen, as well as some of the best things I've seen. I'm going to save the best things that I've seen for another episode, because this has been going long. So again, thank you so much for listening. Hopefully you've made it this far. And with that, we will see you next week.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.